Hello, and thank you for joining us for today's webinar. Before we get started, I have a few housekeeping rules, notes. For the benefit of all participants, attendee lines have been muted. Should you have any questions that you would like to submit during the event, you may submit them through the question and answer space. If we cannot address your question during today's webinar, we will follow up after the program. Please note that today's webinar will be recorded and circulated to all registrants via email after the event. Should you have any follow-up questions at that time, please reach out to any of the key contacts listed in the email communication. Note, Dentons can only issue CLE credit for attendance during the live broadcast of the webinar. Participation in the live webinar must be on a computer or laptop device. Credit is not available for joining via mobile device. One other important note, if you have a New York, New Jersey, Pennsylvania, or Kansas license, please be sure to listen for the code word given during the program. When prompted, you will need to enter the code word into the Q&A section of the screen. If you don't have a license in these states, you can disregard this. All right, so again, welcome. We're going to talk about unclaimed property for GCs. And this is us. Maybe we should take just a minute for each of us to briefly introduce ourselves. Let's start with Lauren.
Hi, everyone. It's great to be here with you today. My name is Lauren Wilson. I am a partner in Denton's Washington, D.C. office in our federal regulatory practice group, and I focus on technology, so helping companies buy, sell, and deploy technology products globally. And as part of my practice, I do a lot of e-commerce work, particularly in designing consumer-facing loyalty and gift card programs. And that is how I got involved with unclaimed property laws.
Thank you, Lauren. Helen?
Yes, my name is Helen Cooper. I'm a tax partner. I sit in Denton's Louisville office. I began my career in creditors' rights litigation, and then I became a certified public accountant and spent a number of years in a Big Four accounting firm in tax. I now focus my practice on tax controversy, and I'm very excited to speak to you all about unclaimed property. This is very much a hot topic in multi-state taxation. And it's somewhat of a trap for the unwary. So our goal today is going to be to help you gain an awareness of what unclaimed property is and how it may affect certain companies.
Thanks, Helen. So I'm Mark Lloyd. I'm a partner in Denton's Louisville, Kentucky office. I'm one of the co-leaders of Denton's national tax practice. My practice is all tax all the time with the inclusion of unclaimed property, deal with auditors and certainly appeals work. So without further ado, let's take a look at what we're going to talk about today. So our agenda for today is pretty aggressive, but broken up. So hopefully you all will be in this afternoon, at least for us, presentation in the middle of the day. We'll keep it moving, and we'll hopefully present to you some things that you can, new to some, maybe old hat to others, but those who've been dealing with it, maybe hopefully there'll be some nuggets that you can take away. I'm not going to read the whole agenda, but we're going to kind of start off broad, and we're going to talk about some defenses as well, and trends and common types of unclaimed property, and a couple of suggested action items, and save a little time for questions toward the end.
Great. Thanks, Mark. So just to level set, we'll start off by talking about what is unclaimed property. So unclaimed property is an asset. It can be tangible or intangible. And after a period of time of inactivity, during which it goes unclaimed by the rightful owner, the government can take ownership of the asset, and the property is deemed to have been abandoned. Each state has its own laws related to unclaimed property, and there are several model acts in place that various states have adopted, but the laws can be nuanced. So there really is a state-by-state assessment, such that the nuances about jurisdiction, reporting, where you're domiciled can all impact the laws that apply under a state framework. So it's important to pay attention to all of those topics coming up. Holders of unclaimed property are required to track, report, and remit that unclaimed property pursuant to the laws of each state. And this is enforced through audits carried out by unclaimed property examiners in each state. Really, any company can be subject to unclaimed property laws and should be paying attention to compliance. There are dozens, if not hundreds, of vendors to help you with this compliance. But as time goes by, trends emerge, and so particular attention may be paid to certain industries that are more likely to have, you know, millions, if not trillions of dollars in unclaimed assets. And so particular attention has been paid to insurance industries, gift card processors, investment accounts, and more virtual currencies. And we will talk about all of these industries and emerging trends later on in the presentation.
So unclaimed property has its own language, and it's very important to understand some of the key terms that are important. So just to start off with, I'll give you a few examples of transactions. So imagine a bank opens a deposit account for a depositor. In that transaction, the bank is the holder of property, and the property is the deposit account with funds in it, and the owner is the depositor. I'll give you another example. Retailer sells a gift card to a customer. In that transaction, the retailer is the holder of property, the property is the gift card, and the owner is the customer who purchased the gift card. So this becomes important because states, when they start to come for, they start to do these audits, or they request reports, they request them from the holder of the property. And so it's important to understand first, as a baseline, what a holder is. So the Supreme Court in the seminal case, Delaware v. New York, defined an unclaimed property relationship, and it also delineated what a holder is, and it described this as a debtor-creditor relationship. You may also think of it as a bailment type relationship. Essentially, what a holder is someone who holds property for someone else. There, as Lauren mentioned, there are a number of model acts, and we'll go into those a little bit later. But under those model acts, holder is specifically defined. For example, on the screen, we have the definition of holder from the revised Model Act, and that act defines a holder as a person obligated to hold for the account of or deliver or pay to the owner property subject to the act. So it's the person who holds the property for someone else. It's also important to remember that because states adopt these laws on their own, they may have tweaked or changed or adopted their own definition of holder. And as well as some of the other language that we'll talk about. It's important to remember that there is federal precedent that says that states cannot override judicial rules that are validly fashioned, similar to how they can't override acts of Congress. So federal preemption may apply where there is a dissonance between a state law definition and a federal judicially fashioned definition. Owner, we've talked about this a little bit, but also the Revised Model Act gives some very specific inclusions into the term owner. So an owner is a person that has a legal, beneficial, or equitable interest in property. This may be a depositor of a deposit account, a beneficiary of a trust. We've seen a lot of activity lately in terms of trusts, because if you think about it, I mean, that's the sort of thing that could go unclaimed. People come up with their estate plans and then they live for years and years, and their beneficiaries might not even know that they're a beneficiary in a trust account. And so, those types of property could go unclaimed. Creditor, claimant, payee for other property, or a lawful bearer of a record that may be used to obtain money, a reward, or a thing of value. Now that's a very interesting one because this definition has been applied oftentimes to intangible assets that are electronic. So you may think electronic rewards or electronic currency, where essentially the property is created in an online environment, and the owner has to go onto an account to access it. Interestingly enough, a lot of states have started to specifically define cryptocurrency as property. So it becomes important to understand the state law definition in a particular state. Property can be tangible. Oftentimes, when we're talking about unclaimed property, we're talking about intangible assets. And the reason for that is sort of obvious, right? If you have a tangible asset and it's worth something, usually somebody knows about it. The car that goes unclaimed, if it really is going unclaimed, it's probably because it's not worth anything. But an intangible asset is different, right? Because people will create these assets, or they may create them for someone else, and they exist in an intangible form. And so people may forget about them. They may forget that they own them. And so that's sort of the fact pattern where we see the most activity with states. So with that,
Helen, can I say one more thing on that slide? I apologize. Sometimes we also have to, figure out whether or not what might be of interest is property or not. Is it even property, in the hands of the holder? So that's often a question, that comes up. So just wanted to flag that.
Well, I'm so glad you talked about that because you're absolutely right. And that's a lot of times why we see states expanding their definitions to try to mitigate some of those arguments for what is or is not property. But also we see on a holder's side that there are some things that a state might try to define as property that, clearly doesn't seem to be a real property interest. And so it becomes important to determine where that definition actually lies. And it can be a source of controversy and a source of increased analysis. So it is certainly something to flag.
Thanks, Helen. So who wanted to talk about English common law today? I guess I did. So unclaimed property has its roots, in that, and that's how we get, some of the word escheat, which we often talk about in place of unclaimed property. And it developed out of English common law concepts in which a landlord or the crown had a claim to property when the true owner, of the property was, unknown. So if you didn't know who owned it, then it would revert to someone else. So that's kind of the origin of this. And for those of us who are interested in historics or historical development of these types of concepts. But let's get a little bit more practical and talk about the Uniform Unclaimed Property Act. So earlier, I think it was mentioned that each state can have their own unclaimed property laws, and they do. But how do you keep track of these things in your mind or on your or to manage them when you've got 50 states to deal with? The way I try to do it, and I know my colleagues do as well, is you can kind of categorize the regimes into similar laws. They're not exactly the same because they often the states often modify them. But one way of getting your arms around 50 states worth of different types of laws, whether it's an unclaimed property or sales and use tax or state income tax, etc., is kind of grouping certain states similarly. So the first category is those states that adopted the Uniform Unclaimed Property Act. The first version came out in 1981 and attempted to resolve obviously conflicting personal jurisdiction claims over the holder of abandoned property, and it's been adopted in various forms by 33 states in the Virgin Islands. In 95, a new edition was adopted to address issue raised in the Delaware v. New York case and to try to simplify the UUPA. And it was adopted by 15 states in the Virgin Islands with some substantial modifications. But that's not the end of it. Later, we've gotten the revised Uniform Unclaimed Property Act, and it was adopted in 2016 by the National Conference of Commissioners on Uniform Laws and served as the base for the ABA's draft model Unclaimed Property Act, which was issued in 2018. The ABA version makes some changes, and some version of the RUUPA has been adopted by over 10 states. So this is another, iteration of unclaimed property laws that have been enacted by the states. So yet another category. And of course, they're the outliers. They're the states that have, kind of gone their own way. And I probably should have asked you to guess them, guess the states before we showed the slide, just as a little guessing game for you all. But of course, Delaware, and unsurprisingly, New York and Texas. And I think Helen's going to talk a little bit about some of the different laws in a bit. But for now, just thought it'd be good to go through the jurisdictional requirements. Which state gets to which state does property escheat, which is a big question because it's kind of the first question that you have to ask in certain instances in order to figure out whether particular types of property, whether and if particular it is something even property potentially as well, and if so, where should that go to, and what state laws are potentially at play. So these rules, as you can see, are all developed from case law at the U.S. Supreme Court. You got Texas v. New Jersey or Delaware v. New York, etc. And they are all kind of the basis for this. So you take that and you've got several kind of rules. So the primary rule is that property is subject to escheat only to the state of the last known address of the creditor, as shown by the debtor's books and records. So you look to books and records to see if you are able to figure out which state that property is going to escheat to. Now, if the records do not disclose an address, or because the last known address is in a state whose laws do not provide the escheat, which is another complication, the secondary rule awards the right to escheat to the state in which the debtor is incorporated. Thus, thus you can see why Delaware is such a player in unclaimed property, because a holder's state of incorporation for a corporation is the state of domicile. So pretty normal, so that's why many companies are incorporated in Delaware, and so that's why you end up with Delaware being such a important part of unclaimed property and often analyzed. So regarding LLCs, though, the states are split, as to their definition of domicile. So you could get whipsawed one way or another if you have an LLC and the principal place of business is different than the domicile of the LLC state of formation. That's often that's a pretty typical circumstance, because for other tax purposes it might make sense to form your LLC in one state and have the primary place of business being in another. So but this could come into play certainly in a unclaimed property context.
Yes, and I'm glad you said that, Mark. Delaware is a major player. Oh wait, I'm sorry. We have a slide interruption. As mentioned, let me talk about this first. As mentioned at the beginning of the webinar, we need to take a brief moment to satisfy CLE requirements by delivering the following code word. All Kansas, New York, New Jersey, and Pennsylvania licensed attendees must type the code word property into the Q&A section of your screen. Please make sure to hit the send button so that it registers. In case you missed it the first time, the code word is property. All right, so now back to our scheduled content. Delaware is a major player in the unclaimed property scene. Again, as Mark noted, so many states are incorporated or organized in Delaware. So what we've prepared is a little bit of a state-by-state overview of different reporting and remit and notice requirements. And those are subject to the big players, including Delaware. But first, to lay the scene, it's important to understand that to be subject to escheat, under the derivative rights doctrine, which is a judicially created doctrine fashioned by the Supreme Court, the owner of the property must have an unqualified entitlement to that property. And further, that owner must abandon all rights to the property. So it's really a two-part analysis. First of all, does owner actually own the property? And the idea here is that the state can't take anything from a holder that the owner itself or him or herself could not take from the holder. So you can't have an invention of property. There has to be a real property right. Further, the owner must actually abandon that property. So abandonment is it's an interesting concept. It requires an owner to have an intent to abandon the property, and also to either commit an overt act or a failure to act that implies the owner does not claim or retain any interest in the property at issue. So there is a general presumption against escheat, right? we don't really want property to go to the state as a policy matter. And so in order for that to happen, the owner really has to walk away from this property. And so in terms of abandonment, what you see a lot is a period of dormancy in which the owner does not contact the holder, or is unable to be contacted by the owner. Generally, each state will define a presumed period of dormancy to the point of abandonment. And some states also will require reporting in the case of a holder that doesn't necessarily have any property that may be subject to this cheat. So it's important to remember that just because there's no abandoned property does not mean that there's not also reporting. And oftentimes these are controlled by jurisdictions, such as, if you're incorporated in the state or if you have business activities in the state, then you may have to file a unclaimed property report, known as a negative report. So again, that major player, Delaware, in terms of an abandonment period, again, that's the period of presumed dormancy, after which the property may escheat to the state. For Delaware, it's generally the earlier of 5 years after the owner has a right to demand the property, or the obligation to pay or distribute the property arises. Again, that might be a little bit different, depending on the specific property, but in general terms, it's usually 5 years. Delaware also imposes a notice or due diligence requirement on the holder of property. The holder must send notice to the owner by first-class mail, usually no more than 120 days or less than 60 days before filing an unclaimed property report. There are some exceptions to this rule. For the example, if the holder doesn't have a valid mailing address for the owner, and this happens all the time, right? People buy a gift card and then they move, or they curb some sort of they deposit an account and they move and they forget about it. So if the holder doesn't have a valid mailing address, then they don't have this notice requirement. And then if the value of the property is less than $50, then that due diligence requirement goes away. In terms of reporting, if you do have a reporting requirement in Delaware, then a report must be filed by March 1st. Another big player is Illinois. So in terms of an abandonment period, property is deemed abandoned in Illinois when the owner doesn't take action. This dormancy period varies by property type, but it's usually about 3 to 5 years. Also, a holder in Illinois has a due diligence requirement. They have to send notice to the apparent owner of the property, informing them that if they don't contact the holder within 30 days, then the property may be turned over to the state and sold. And a report is due from a holder by May 1st of each year. New York has a similar abandonment period to other states, generally 3 years, but note virtual currency is up to 5 years before it's deemed abandoned. Likewise, New York has a due diligence requirement requiring the sending of written notice to the apparent owner by December 10th, preceding the reporting requirement date. But this requirement is subject to exceptions. For example, the holder doesn't have the address of the apparent owner, or is not able to otherwise find the apparent owner, then this requirement is not in place. In terms of reporting requirement, written reports are due. When written reports are due varies by the type of property, but generally there is a March 10th filing date. And finally, California. California is always a little bit different. The California requirement is generally 3 years for all intangible property. Holders of abandoned property have to are subject to due diligence requirements for property worth at least $50. Notice must be provided between 2 years and 2.5 years after the last communication or activity with the owner, or between 6 months and 1 year before the account is reportable to the controller. California has its own reporting process. It's actually a 2-step process. So there is a holder notice report required to the controller by November 1st of each year. And thereafter, a holder remit report is due by June 1st between June 1st and June 15th thereafter. So there's an opportunity to give sort of a preliminary report and then a final report later in the year. With that, I'll turn it over to Lauren.
Thanks, Helen. So now we'll go over some common types of unclaimed property, starting with my personal favorite, gift cards. So companies that offer gift cards or gift certificates or other stored value cards should pay very careful attention to state unclaimed property laws. This area is one that can trip companies up quite a bit because of the variances among the states. So many states actually expressly exempt gift cards from escheatment if they meet certain criteria. For example, the cards don't have an expiration date or don't have any fees associated with inactivity, dormancy, activation, things like that. And so that can impact how you design your gift card program often. Other states, including Delaware, expressly require the escheatment of gift cards. Another variance among states is some states allow the holder to retain a portion of the unclaimed value, and a handful of states require the entire balance to be remitted to the states. So it's really important to complete, the relevant jurisdictional analysis and figure out, how you need to comply when it comes to gift cards. A major part of the determination will be based on whether your business keeps track of the cardholder's address, either because they have to enter an address when they purchase the card, or they purchase a card under an account with your company that has their address. And so those are all things you want to keep track of. Another common type of unclaimed property, which is gaining more attention, is virtual currency. A lot of states have been expanding their unclaimed property laws to include virtual currency or cryptocurrency. So if you offer this type of currency, you should expect to have to report and remit currency. You should also be aware that some states will require you to liquidate the currency before reporting and remitting it, and some states allow you to, remit it in its original form. Some examples of states that are, paying close attention to virtual currency and updating their laws are Connecticut, Maryland has just updated their law, or is introducing a bill. So that's something to keep track of. Also, several states are adopting a presumption that virtual currency has been abandoned where the owner has not accessed their account or the system for viewing the currency after a few years. And so having the technical capability to, track that is important to operationalizing your compliance. And also of note, as with virtual currency, always, securities investors should keep up with their securities as states have been shortening the abandonment periods by presuming that securities have been abandoned where the owner is inactive or when the holder learns of the owner's death. Another really important type of unclaimed property are investment accounts, in particular, retirement accounts. Retirement accounts represent over $40 trillion of value in the United States and are about, a third of all personal household assets. So it's kind of just a treasure trove for states when it comes to the potential to collect on unclaimed property. And so you will want to talk about that with your advisors, particularly when it comes to ERISA, which lays out different parameters for when an account is deemed abandoned and what those triggers are. In January, there was recently temporary guidance from the Department of Labor, which was brought about by concern over ability of companies to find participants or beneficiaries in their plans. And so in the bulletin, the DOL said that ERISA plan fiduciaries would be allowed to place funds owed to a missing participant in a state fund, provided that the accrued benefit was no more than $1,000. Now, this is only temporary guidance, and the department said that it expects to offer further, more permanent guidance soon. And so that's just something you should be more aware of and be tracking as we look out for that formal guidance. But at the end of this presentation, we'll talk about practical tips and guidance. And I think some of that will be just about how you keep track of things like addresses and everything that will trigger your dormancy periods or the jurisdictional analysis, such that you can be more strategic in trying to maximize the benefit to your organization.
And Lauren, can I jump in, or did you, is that okay?
Yeah, definitely.
I just had one thing to add on this slide, and that's, and I probably should have jumped in a little bit sooner, kind of like right after gift cards, because one of the things, Lauren, I know you and I both worked with our clients a lot on, it's rewards programs. And one of the questions for that is often, whether or not it's property in the first place, and then what do you do with it? So it's just a category that I think I just wanted to throw that in, even though it's not on the slide, that folks ought to think about. Thanks, Lauren. That was it. Just had a quick comment.
Thanks. Yeah, super important. An analysis we do for our clients all the time when designing their loyalty programs alongside other benefits for their customers.
That's right.
Well, if it's all right, if I jump in, one of the things I think that is really interesting about this slide too is, and also Mark and Lauren's discussion is you can see that there are certain trends, right, in unclaimed property. There are certain property types or company types that are a little bit more on the radar where this comes up more often. And so it's important to remember that if you're at a company that issues gift cards or holds securities or provides dividends, say publicly traded, that you may be on the radar of these states that you operate in terms of unclaimed property. So it's important to remember, while it's important to do your own analysis, there are also states out there doing an analysis for you. And so, we'll talk later about, what you need to do to be prepared in case a state, comes and starts to ask for that property report.
All right. So defenses to state escheat laws. So let's talk about that for a minute or so. And we'll start with the derivative rights doctrine. So, you know, as you can see, a state generally has no greater rights to property than the owner of the property. So in other words, this can be somewhat circular, but it basically means that if the owner of the property doesn't have rights in property, then or their rights have expired or terminated, then how could the state have, more rights in it? And that's in this defense, or this doctrine is rooted in the U.S. Supreme Court precedent, which says that it's the debtor-creditor relationship is defined by the law that creates the property at issue. So there are some exceptions to this. One is many states have anti-limitation provisions, and so that can sometimes keep, for example, expiration dates, from, or at least in the state's minds, it can keep the derivative rights doctrine from applying, and a rule against private escheatment, which means as the property escheats, to the holder, for example. So in developing a defenses to state escheat laws, especially for types of say for things that may or may not be property, we need to think about these things and how they line up, the derivative rights doctrine and the exceptions that the states have attempted to carve out, whether legislatively or judicially. And then one of those, defenses that we have, a couple of defenses that we have are in the federal Constitution, which provide limitations on the states. One is that state law, can be preempted by the federal common law of unclaimed property, as well as the federal statutes. So there is, there certainly is a federal preemption defense that can be thrown in. And another thing to look to is the takings clause. So a holder, generally has no property interest in, for example, in abandoned property. In the context of unclaimed property, the property owner must establish a property right. So in other words, in order to, so the takings clause can come into play as well. Yeah, I think it's probably good. Let's move on to the trends given the time, Helen. And it's Lauren. Lauren, you're up.
Sorry, I was muted. So each state will have property examiners that administer audits in order to take stock of the unclaimed property to which the state is entitled. We've been seeing kind of 4 different trends in how states are approaching audits. And, as states' views and laws change on unclaimed property, so are their kind of examination procedures. So one such program is kind of a voluntary disclosure program. And that's because it's designed so that companies that have underreported or failed to report their unclaimed property can come into compliance. And many of these programs allow companies to do so without penalties or interest, because states, just are interested in getting access to that revenue. So I want to facilitate that happening as, efficiently and quickly as possible. Similarly, Delaware, where this is a really huge topic, has introduced a verified report program. And so Delaware holders of unclaimed property can review and correct their most recent annual filing or non-filing. But in Delaware, a failure to timely complete the verified report process within 1 year with no extensions can result in being referred to the voluntary disclosure agreement program for additional enforcement action. So again, when you have unclaimed property in Delaware, you just really have to be on top of things. Alternatively, you can participate in a compliance review process there, and that operates similar to the Verified Report program, except that data requests can cover reports going back 6 years. And so that can kind of inform, how long you hold on to relevant records. There are also self-reviews and self-audits. And so that's a more proactive approach that requires holders to examine their own records and report any discrepancies or omissions in prior reporting. And so you should also be aware that publicly traded companies are subject to, additional scrutiny on dividend payments and tracking missing shareholders. And so that's something to be aware of. Also, if you're a holder that outsources payment functions to a vendor, you have to disclose the details of that agreement during your audits, including any reporting that your vendor may do on your behalf. And so I think it's, also to be important to be aware of trends in audits and data requests. And so organizations that may be targeted by a given state, of course, are organizations headquartered in that state. So, Delaware is very active, headquartered and domiciled. So that's why you see Delaware being very active on audits. You may also see Delaware being kind of active when the state is aware that you may be trying to kind of disguise your domicile, or are you creating subsidiaries or shell companies in order to make a gift card offering, for example, when really that company doesn't do anything other than enter into the contract for the gift card. And so Delaware may be under the impression that you are just trying to keep the gift card proceeds away from the state. And so that can make you a target. Specific industries, healthcare, insurance, in the financial sector are also ripe targets. And so it's really important for those types of organizations to be on their P's and Q's, and organizations that have, just very robust and popular gift card programs also maybe targets as well.
And Lauren, just to jump on a little bit about Delaware. Delaware, again, is very much the cutting edge. But about that verified reporting, remember, Delaware has a reporting requirement already. So when a company is selected for a verified report, it's sort of an audit before the audit. It's a more intense report that may cover the same information that was included in the report that was already required, but it also may subject a company to have to update that report. The same thing with a compliance review, where it's not exactly an audit, but if you don't comply, or if they find something, then it could result in an audit. So it's very important, if selected for a verified report or compliance review, that a company is ready to be responsive to the state and also has the information handy that they need, because both of these programs, or at least the verified reporting program, requires very specific response requirements. For example, a Delaware verified report requires a 30-day response. Extensions can be received, but the whole verified reporting exercise must be done within a year. So, so it's important to keep on top of it, especially if you have any ties to Delaware or any other state. For example, California also does these verified reports.
Thanks, Helen.
All right, action items for general counsel, and I'm going to invite Helen and Lauren to, of course, weigh in on these topics, and as opposed to like jumping in, all of these. Let's start with evaluation of unclaimed property at the company, because I think all of us have something to say about this particular topic. We do a lot of this, and one of the things I think, if I had to reword this, I might say unclaimed property risk, because especially in the rewards program space, we're trying to figure out, is this property, have we has a right been created, or if we're there on the beginning of the development of the rewards program, how can we help develop a rewards program that manages unclaimed property risk from the get-go. So I'd be interested in Lauren and Helen in your thoughts on this as well.
Yeah, I think when designing loyalty programs, it's important to consider not only the loyalty points, but the rewards for which the consumer can redeem their loyalty points. And kind of once that redemption happens, assessing whether that reward now becomes property that could be escheated, and whether those rewards also become gift certificates, under the relevant laws. There's a whole analysis that can flow from these consumer-facing programs where you may or may not be creating property that companies should be thinking of and tracking, as they set out to design these programs. Also, the personal information you're collecting about your consumers when you offer rewards or points. There are privacy concerns, but also that will impact your jurisdictional analysis and the state whose laws you'll become subject to. And so taking all of those factors into consideration, as well as, will you set up an affiliate to administer the program, and how to get that affiliate involved in your larger organization such that it's, will likely be viewed as a true company that is separate from the parent and not subject to the laws of Delaware. And so, I think there are all these considerations at the outset that we can help you think through that are kind of really important to compliance here.
Thanks, Lauren. Helen, did you have anything to add on this? Or I know you talked to us a lot about state reporting and payment requirements. Would you like to comment on that?
Well, the best defense is a good offense, right? So I completely agree with yours and Lauren's sentiments that when you're designing a program that will be subject to reporting requirements, or that may generate attention, that it's really important to think about unclaimed property implications from the beginning so that you can head off these areas of controversy before they begin. In terms of state reporting and payment requirements, it is absolutely it's absolutely vital that you understand the states that you are involved with, what their reporting requirements are and what their payment requirements are, so that you can comply. And again, you can head off any potential controversies before they arise, or you can prepare a defense in case it's not possible to head off those sorts of controversies. So again, highly recommend looking through your intangible accounts, looking through the different service offerings you have, and understanding what might trigger a reporting.
Helen, good thoughts. So on development of defenses to audit enforcement, I think this is a really good action item. You really need a thoughtful strategy for dealing with unclaimed property and this potential unclaimed property and this cheap exposure. Thinking about what states could be looking at this, or what states do we want to be involved versus what states may get grabby as it relates to the particular item or account. Is it actually a property or not? Is that a potential defense? Are we relegated to the derivative rights doctrine? Where are the potential owners? Do we have defenses or strategies around those? So lots of things to think about, as it relates to developing defenses to audit enforcement. And we often see this kind of dovetail in with preparation for potential sale, because these can be big issues, and getting one's arms around them on the front end, and when there's a longer runway, so to speak, often can potentially allow for maneuvering in advance of a liquidity event, for example. And then the last point is preparation of an audit ready package. So I think if you look at the top three bullets, you can certainly use those three action items to help develop what are we going to do when there's an audit, how are we going to respond, what are our areas of exposure, how can we mitigate that, and when we're ready for an audit, how do we deal with that? Okay, and looking to any other comments on this, Lauren or Helen, before we move on to I think we probably have a Q&A slide, but I don't think we have any questions at this point. So we've got about a minute left. Any final thoughts, Lauren, Helen?
Oh, I see one question.
Okay.
If a holder company's subsidiary is located overseas, is it still subject to an unclaimed property state? Do you want to take that, Mark?
It depends on where the property is. It depends on where it's located. I guess early on we talked about where should it where's the owner? Can you locate the owner? So for example, if it were foreign addresses, foreign potential owners, then I think you'd have some things to think about. I didn't see where that was at in the question. I was trying to read it. But hopefully that's at least that's my initial, thought on that. Oh, here we go. There it is there. Is it still subject to? Yeah, it's the holder, the company, a holder company. It is potentially, it just depends on where the, where the account holders are. And there are other jurisdictional questions, I think, related to that. So, I mean, that's probably going to take longer than we have to address, but we can look to get back with you on that.
Yeah, it's certainly possible that it could be subject to an unclaimed property state, if all of the criteria are met. So, we have dealt with foreign retailers that have operations in the US, but their offerings are still formally out of Europe, for example, and they're selling gift cards all throughout the United States, to the extent that they are collecting the kind of address of the gift card owner. One way in which that happens is because the gift card owner gets it mailed to them, or because the gift card owner has an account on the retailer's website for their rewards program and they buy their card that way. Then kind of knowing the address of that gift card holder could mean that the unclaimed gift card balance is subject to, escheatment.
But there are some potential defenses that we could also talk about as well. And we're over time, so we need to get to the next presentation. So thanks for listening, guys.
Thank you all.
Thank you.
Great. Thanks, Mark. Thanks, Lauren. Thanks, Helen. Hello, everybody. My name is Peter Stockberger. I'm a partner at Denton's based in our San Diego office. And with me is Dalton Klein, who's an associate out of our Louisville, Kentucky office. And we're going to switch gears now and talk about data privacy compliance in 2025 and the complicated landscape that we all find ourselves in navigating this emerging federal and state patchwork of data privacy laws. So we're going to be spending some time walking you through an overview of what the US landscape looks like at the moment with regard to data privacy, compliance, laws, regulations, and litigation trends. We're then going to spend some time focusing on what we see on the counseling side that are common pain points and compliance challenges for our clients. And then we've got some key takeaways and observations to help future-proof the organization as we move into sort of a privacy-first era within 2025. So from a landscape perspective, as it relates to data privacy, I think it's always helpful to start with the concept that the United States does not have a uniform, all 50 state privacy law. We are instead a very fragmented jurisdiction when it comes to data privacy. And that's important to keep in mind because it's often frustrating for organizations not to have a one-size-fits-all when it comes to navigating how to collect, use, and transfer personal information of individuals. So as with most laws, we've got a breakdown between federal and state. At the federal level, we see laws that have general applicability, but also highly specific segmented laws per industry, like in healthcare and finance. So we've got the FTC Act, which is a general law of applicability that governs unfair or deceptive business practices. And the FTC historically has enforced the FTC Act under Section 5 against companies who make promises in their privacy policies or promises relating to cybersecurity that are deemed to be unfair or deceptive. There's a federal law that governs the collection and use of personal information of individuals who are under the age of 13, called the Child Online Privacy Protection Act, or COPPA is the acronym. That law regulates how you can collect the information of individuals under the age of 13, when you need to obtain parental consent, We've got laws regulating how to send commercial emails under CAN spam, how to send marketing messages via text and telephone under the Telephone Consumer Privacy Act, which TCPA, which many of you may have litigated under. We've got a video privacy protection law that regulates how you can share information relating to video watching history, which we'll touch on in a moment, as that's sort of a hot litigation trend at the moment. The financial privacy laws have been around for a while. The main one is called the Gramm-Leach-Bliley Act. This regulates financial institutions, and we've got healthcare laws, HIPAA being the most notable in the healthcare space. At the state level, however, that's where we see most of the action happening from a legal perspective as it relates to data privacy compliance. We've got omnibus or comprehensive state data privacy laws that Dalton's going to dive into a bit more. We've got laws regulating health data, laws regulating data of individuals between the ages of 13 and 18. We've got biometrics laws, insurance laws, financial laws. So bottom line, the landscape around data privacy compliance and legal and regulatory requirements is highly fragmented in the US and requires careful consideration regardless of the use case or industry that you're in. So to dive a bit more on the federal side, right now the regulatory picture at the federal level is a bit unclear because we don't quite know where this current administration is going to head with regard to enforcement priorities. The FTC under the Biden administration was becoming fairly aggressive with regard to its investigation and enforcement of privacy violations. They were focused in particular on the use of third-party tracking pixels on websites. There's a new FTC head that's been appointed by the president. We don't yet know what the enforcement priorities are going to be there. So it's a bit of a known unknown at the federal level. With regard to healthcare privacy, the HIPAA privacy rule, obviously still in effect. HHS still charged with enforcement. Whether that's going to be an enforcement priority with the new HHS, with new leadership, still remains to be seen. The same can be true for financial institutions in regulation and enforcement under the Gramm-Leach-Bliley Act. I think COPPA, we've seen a new rule was released by the Biden administration updating COPPA. Whether that's going to stick around in the new administration, again, we still don't know. One important development at the federal level that we wanted to highlight for everyone is a new rule that came out from the Department of Justice, effective April 8th. And this new rule restricts how US companies can export or make available sensitive personal data of US residents to countries of concern or people of concern relating to those countries. And those countries are the ones that you would probably think about: China, Russia, North Korea, Iran, and Venezuela. Now, many of you may be saying, we don't send data to these jurisdictions, we don't send data to companies in these jurisdictions. But I think a unique element of this rule is that it can impact how you are deploying third-party tracking technologies on your websites and your mobile apps. In particular, if a third-party tool that is running a pixel or a cookie is controlled by or has workers that are employed by a company in those jurisdictions. So certainly an important rule to follow because we really have not seen data export restrictions from a US perspective thus far under US law. That's mainly been a European or a more foreign concept. The other item at the federal level that I wanted to make sure was on everyone's radar is relating to the Video Privacy Protection Act. So this is a law that's been on the books for quite some time and was passed by Congress after Robert Bork's Supreme Court nomination hearing happened. And during that confirmation hearing, there was a newspaper article that released some of Mr. Bork's video rental history. And I think Congress got a little spooked that their video rental history might become public. So they passed a law that restricts a videotape service provider from disclosing the video watching history of a consumer without consent. And for years, that law was relatively dormant. But recently, the plaintiff's bar has been using this law to allege that if a company has a video component on its website or its mobile application, let's say an embedded YouTube video or a native video. And they also have a third-party cookie or pixel on the same website. The allegation is that the third-party pixel owner is pulling in information about what video the user watched. And therefore, that's the equivalent of sharing videotape service history with a third party without the consumer's consent. So there's increased litigation around this. There's a circuit split on definitions. But I think the key takeaway here, and Dalton, this is sort of a common theme throughout, is you've got to know this is a problem in order to spot it. The compliance piece of it is relatively straightforward, which is ensure that the third parties on your website are not collecting things like the title of the video or any substance related to the video that's being watched. That's where the plaintiff's bar is really focused in their litigation. Getting consent under this law is very difficult because it has to be separate, it has to be clear, it has to be at the point of collection. So really compliance is a better approach than obtaining consent in mitigating your risk under this law. So that's a very brief overview snapshot of what's happening at the federal level. And Dalton, I want to toss it over to you to dig into and kick us off on the state level, because I really think the state level is where most of the activity is and most of the compliance challenges sit.
Thanks, Peter. I think that anyone on this call or listening to this presentation is going to be aware of the growth of comprehensive U.S. privacy law. It's not going to come as any surprise that we're kind of pounding that drum, but I think a graphic like this can really drive home how important the legislation shift has been in the past couple of years. Going back to 2018 with California responding to the European GDPR with the California Consumer Privacy Act, we didn't really know what the trend was going to be like. And now 5 years later, we have 19 jurisdictions covered under comprehensive laws, as well as Florida. And then there's very many sectoral or processing activity focused laws that we'll be getting into in a moment. But if you look at a map, like we have on this next slide, you can see the patchwork is creeping. It's a good to guess that if you aren't currently covered by any of these states or their regulations, you will be in the next year or two. We have seen in the past few years, past 4 or 5 years, attempts at a federal privacy law that would potentially preempt these state laws. There doesn't seem to be an appetite for that right now. There's no gas for it. So right now we are, for the moment, stuck with the patchwork. We have Florida kind of blued out there because we count it a little bit differently. But we expect that this patchwork is going to grow. On this next slide, you can see proposed legislation. So this was current as of April 10th from the International Association of Privacy Professionals, but we can see a number of additional jurisdictions and some showing multiple laws. I remember being able to rattle off just California, Connecticut, Colorado, Utah, and Virginia for a while. It was a mantra. But now you can't hold the whole list in your head. I constantly have to check external resources and our own documentation to double check and make sure I'm not missing anything. So in addition to, or when you're analyzing those comprehensive privacy laws, there's some key features that you want to keep an eye on. So every state but California basically is 95% similar, but it's that non-overlapping 5% that causes the huge compliance burden. If it was really just we had one law that was being followed consistently across jurisdictions, it wouldn't be too much of a burden. And yet we see in practice that those small variances between jurisdictions are what cause the biggest compliance burden. The very triggers is kind of the first thing to analyze. The first laws in California and in Utah, Virginia, and others, they had either revenue thresholds or volume of data subjects whose personal information was being processed. And those were, you could understand them. It was difficult sometimes to tell what it meant to do business in a particular jurisdiction and whether or not that was different than what activity would be necessary to establish personal jurisdiction in a court, but it's more complicated now. Texas and Nevada in particular have laws that apply to anything that's not a small business under the Federal Small Business Administration. And that analysis has to take into account not only your revenue and your number of employees, but your particular industry. It's not static across, there's not a single definition that's static across all businesses. The Colorado Privacy Act was also amended last year to apply to anyone who processes biometric data in Colorado. So the triggers for jurisdictional application are not only varied, but they also change over time. It's not enough to have done the analysis once. It has to be continuously done. There's also broad definitions of personal data. Again, most of them are very similar, but I know that Oregon specifically references a device that can be connected to a consumer. So that might be plain from the definition, but they're wanting to make very sure that even online identifiers like cookies and pixels, like we've been talking about, that those are enough to be personally identifiable, perhaps on their own. Maybe the most significant difference, and the one that's most operationally impactful, is the definition of sale. Under the majority of jurisdictions, it is both what you would typically think of as the exchange of data for personal data for monetary consideration, but it also includes any other kind of benefit. And we saw in some enforcement actions from the California Attorney General that the threshold of what's considered valuable is extremely broad. It can be the benefit that your business accrues from deploying analytics and analyzing website traffic. So even that kind of benefit may be enough to be considered a sale, and then all of the attendant obligations regarding disclosures and getting consent for particular use cases and performing impact assessments and allowing people to opt out. So those cross-jurisdictional differences in the definition of sale can be extremely impactful. Increased enforcement is also a large concern. I recall at the end of 2024 having conversations about essentially, year-end conversations about what we should expect in the next year, what are going to be our top priorities that we're going to be counseling clients on. And it was an open question at that time whether or not we would see significant enforcement action under these laws. The California Privacy Protection Agency had been in effect for a year or two at that point, hadn't had any significant enforcement actions. The state attorneys general had these laws on the books. They were enforceable, and yet there hadn't really been any significant movement besides California in a handful of cases. No communication from the state's attorneys general about what their enforcement priorities are. And that is simply not the position that we find ourselves in today. Earlier in the year, the Texas Attorney General brought some of the first enforcement action under the Texas Data Security and Privacy Act. The California Privacy Protection Agency has brought their first enforcement action independent of the California Attorney General. And literally, and this is how quick things move just today, California, Colorado, Connecticut, Delaware, Indiana, New Jersey, and Oregon have established a consortium via a memorandum of understanding where they're going to share information, assign enforcement priorities, look for opportunities to collaborate and work together. So we're going to see increased enforcement from some of these agencies, and we expect that the risk is only going to for enforcement activity is only going to increase.
Yeah, Dalton, I think that's a really important point, because these laws can be complicated to navigate. They can be overwhelming for smaller businesses to figure out if they're even covered. So I think it's important always to reinterrogate whether your organization triggers these laws to begin with. And then second, pay attention to all the different areas that these laws can impact, which include not only your privacy policy on your website and your mobile app, but it can impact in-person collection of data through email, over the phone, It can impact your use of advertising and analytics. As Dalton noted, the sale of data could be occurring on your website, and yet you don't know it because a pixel or a tag was added by the marketing department 1 to 2 years ago, and legal was not advised of it. There are these data minimization principles that are making retention complicated area and contracting requirements. Dalton, as you noted, the California Privacy Protection Agency just recently announced a settlement where they were focused on highly technical violations of the California law. Even going down to saying, if you have more than one click to opt out of something versus one click to opt in, that violates the symmetry of choice requirement under California law. Or you do not have sufficient validation procedures for data subject requests. So highly technical laws, they can be complicated, but as Dalton noted, there is a strategy to ensuring compliance across the board. Another area of state laws that are sort of overlapping with those comprehensive privacy laws are laws relating to health data. So there are a handful of states now that have laws on the books that have specific requirements as it relates to notice, consent, processing restrictions, contracting requirements, as it relates to data that concerns an individual's physical or mental health condition. So Washington State, for example, has the My Health, My Data Act that took effect May of last year and has a private right of action attached to it, meaning you can be sued for not having an appropriate privacy policy under that law. This law's got specific requirements about a link on your homepage, what needs to be in the Washington privacy notice, and this can impact companies who are just collecting information about skin condition or hair condition for determining a product recommendation. So very broad law, not just limited to HIPAA covered data. It can be any data relating to physical or mental health. Nevada has a similar law on the books. Connecticut has an amendment to their existing privacy law relating to health information. We see New York is considering a similar law. So health data in particular as a bucket of information is getting particular attention. And the comprehensive privacy laws, Dalton, that you just mentioned before, they specifically call out health data as a piece of sensitive personal data requiring consent. So if your organization is navigating, collecting, receiving any amount of health information about an individual, it's really important to dive deep on potential compliance requirements and triggers, because this is a new and emerging space. Another space that I think
Peter,
is—
could I say something about the health data?
Please, Dalton. Go for it.
One particular thing to note as well is that, as Peter was going over the federal laws, everyone on the call has probably heard of HIPAA. I'd be surprised if you hadn't, but an interesting thing to note is that these federal laws that are getting kind of long in the tooth at this point, they were passed in a day and age before smartphones most of the time. And so the definition of PHI in that context and what is considered de-identified, if you're operating in a regulatory gray area where you're not a covered entity, you operate as a business associate sometimes, but sometimes you don't. You're dealing with health information that may not qualify as PHI. It can be a really complex analysis. And to Peter's point about the private right of action, especially under the My Health, My Data Act, the risk is immense, especially when you consider that some of what the Attorney General in that sense is looking for is not explicitly in the law. There's something that Peter pointed out to me months ago where there was sub-regulatory guidance issued by the Attorney General specifically stating that the My Health, My Data Act notice needed to be a separate notice from your comprehensive notice on your website. It couldn't contain any information that's not required by the My Health, My Data Act. And so even understanding all of the applicable requirements under the law, it's not enough to look at the law and the regulations. It's also necessary to look at interpretive guidance from the regulatory authorities.
Yeah, and one question that came in, Dalton, was if you're a covered entity or business associate under HIPAA, how do these state privacy laws interplay? And the short answer is that you've got to carefully examine each law because some of them contain a HIPAA entity level exemption for covered entities. Some of them covered both at an entity level, covered entities and business associates, but some are a data level exemption and some don't have an exemption. So there's not a blanket answer across the board, but if you're a covered financial institution under GLBA, if you're a credit reporting agency under the FCRA, if you are a covered entity or business associate under HIPAA, there are exemptions built into these laws. And Dalton, I know another category of laws that are causing compliance headaches are around biometrics, which has been an issue that we've been dealing with for quite some time.
Yes. So as Peter alluded to, we aren't sure how the current administration is going to apply the prior administration's enforcement priorities. So whether the FTC is going to take a similar tack to enforcement priorities and interpretation of precedent is an open question. But we do know that regardless of how the FTC themselves view this prior guidance, we know that state attorneys general rely on FTC interpretations even after the administration changes. The Texas Attorney General in the enforcement action I mentioned previously alluded to not even the official FTC interpretation, but the comment of one of the commissioners in interpreting their own biometric privacy law. So whether or not the FTC continues on the current track where since some sensitive information is going to require a GDPR-like consent, which would be freely given, specific, informed, and unambiguous, regardless of whether or not the current administration follows that, state attorneys general may continue to do so. The Illinois Biometric Information Privacy Act has been a pretty hot ticket litigation item, particularly from employees that are using biometric time entry mechanisms. Consent and express notice are required. It has a private right of action, which is always attractive to plaintiffs' firms. But in addition to Illinois, Texas and Washington also have these biometric privacy laws. And the Texas statute, you might read it and think, well, this is a little bit more narrow than the Illinois use case because it only covers commercial purposes. Well, if you look at how the Texas Attorney General has interpreted what constitutes a commercial purpose, it's actually incredibly broad. We've seen that commercial purposes can include things like the capture of a biometric identifier by an employer for security purposes, the general improvement of existing services and products, trying to increase advertising and subscription revenues, training AI models, and in one case, the alleged commercial purpose was trying to keep the defendant's products and brand competitive in the marketplace. It's extremely broad, and so you shouldn't assume that, oh, because we're not selling the biometric information to any third party, we're not disclosing it, we're just using it for our own internal purposes. That could still be commercial, could still be a commercial purpose. Biometric information, as we've alluded to before, it can be considered a category of sensitive personal information for which you have to have consent prior to processing it, and that consumers might have additional rights in. So particularly in the context of California, where the CCPA covers employees, those kinds of disclosures in your employee handbook and making sure that your policies and procedures for hiring capture both that this information, that the notice was given and that consent was collected, becomes increasingly important.
Yeah, I think, Dalton, the key takeaway here for everyone is biometrics can come up in a variety of business cases. You can have employees using biometrics for timekeeping. If people use a facial scan or fingerprint to access their company device, laptop, or phone, that can trigger some of these laws. The FTC's guidance even includes photographs as a definition of biometrics, even though the other state laws exempt photographs. So you can imagine in fraud protection circumstances, potentially triggering some of these laws. And increasingly, organizations are accessing the biometrics potentially on NFC-enabled chips for validating ID. So biometrics is an area where the technology is advancing rapidly. The laws themselves are remaining relatively static, although their application, I think, is expanding into different sectors. And another area where we see the law, old law, applying to new use cases is in this growing litigation landscape, where we see the plaintiffs bar, largely in California, where I'm based, but also in states like Pennsylvania, Florida, and Massachusetts, leveraging decades-old laws that are on the books that relate to third-party eavesdropping or wiretapping, or the use of a trap and trace or pen register device from law enforcement. And they are using those old laws to apply to how third-party tracking technologies are used in today's digital ecosystem. So for example, under the California Invasion of Privacy Act, it is unlawful for a company to aid and abet a third party to eavesdrop or wiretap a communication with an individual without that individual's consent. So the allegation from the plaintiff's bar is that the use of things like the Meta Pixel or the TikTok Pixel or chatbots or SDK, software development kits on mobile apps, or even payment processors such as Stripe are third parties that are coming in and eavesdropping or wiretapping on an electronic communication, i.e. what link somebody clicked, what form they filled out, and that constitutes electronic eavesdropping or wiretapping. So this litigation is prolific. The demand letters are hitting every company of every size. There are some defenses to these claims, consent being one of them, which is why analyzing your cookie banner and whether you're obtaining consent is a really important mitigation step. There are some contractual defenses that you can rely on, some statutory defenses. We're seeing some courts push back on these theories with mixed results, but the plaintiff's bar continues to evolve and get creative under these statutes. So this is an important space to track, and we've got some mitigation steps that we think can address it. But just another example of a litigation trend that you wouldn't really think of until it hits your desk with a demand letter is under the Song-Beverly Credit Card Act. This is the law that's been around in California since 1971. It prohibits retailers from asking for additional personal information at the point of checkout beyond what is on a credit card in order to process the credit card. And there's been some class action litigation that's been filed against major brands alleging that when you fill out a form online before you get to the checkout page, by requiring that person to put in their name, email address, and phone number, you're violating this law because an email and a phone number is not required to process a credit card. Now, there are defenses under the law for collecting information for shipping or for using it for other ancillary purposes, but it just highlights that the privacy risk landscape is not just regulatory and compliance, but we've got an increasingly complicated litigation landscape going on right now, which is why it's critically important for companies to build privacy compliance programs that take into account both the risk from a regulatory standpoint and also a litigation standpoint. So with that, I think that transitions us nicely, Dalton, into what are the compliance pain points that we see? We've got a complicated legal landscape. We all know that. How do you keep track of it all? And where do we see a lot of pressure points occurring within companies? And building off of that last litigation point about the website and the mobile app being potential hotspots for litigation, maybe you can tee up what are some of the compliance pain points that we see every single day working with clients on specifically the website and the mobile app.
Yeah. So as should be clear by now, there can be a lot that goes wrong with website and mobile application. And I mean, even if you do everything right, that probably won't stop the demand letters from coming, but there are ways you can mitigate risk. One thing that we see pretty commonly is a cookie banner that it might say that you can opt out of the non-necessary cookies, and yet when the consumer actually clicks the button, not all non-necessary cookies are disabled. Same thing with tracking technologies like pixels, beacons, those kinds of things. In addition to cookie banners, privacy policies can also be really difficult. it can be difficult to understand how you're supposed to structure them whenever across industries and across even competitors, the the conventions for drafting are wildly different. Specific data point collections, like we see here. So if you have you might only collect data from on a mobile website. You could have an app. You could have in-person brick and mortar locations where you're collecting information. You could be doing events where you are collecting additional contact information um, through registration for things like webinars, like we're having right now. The possibilities are endless. And then same with video file sharing. There's just a lot of companies have a really hard time categorizing and capturing all of the ways in which they're collecting information. Peter, you want to give some examples from your own experience about where you've seen companies have the most pain on their websites and mobile applications?
Yeah, I think let's just start with the beginning, a cookie banner. One of the big points of debate with most companies is, do we need one? Is it legally required? And if so, should we just be telling people that we're using cookies and tracking technologies, or should we be obtaining affirmative opt-in consent? And the answer to that question can actually be relatively complicated, because I think putting up a cookie banner in today's environment is probably, if not best practice, required under some of the state privacy laws. But whether you obtain consent or not is not so clear. And there are a lot of trade-offs with regard to each decision. So for example, if you do not obtain consent to setting things like advertising and marketing cookies, and you're simply telling people that we're using this technology, you have a right to opt out of it, but it's going to be set by default, you could be opening yourself up to litigation by the plaintiff's bar. You could also be setting yourself up for regulatory investigation by agencies such as the California Privacy Protection Agency, because the California law says if you are collecting and using a California resident's personal information beyond what is reasonably necessary and reasonably expected by the consumer, you need to obtain their consent. There's some debate as to whether a reasonable consumer would understand the breadth of third parties that are being deployed on a website. So not obtaining consent can present some challenges, although it maximizes the data that you're collecting. Obtaining consent, on the other hand, can have a significant impact on the ability to collect and use data from an analytics standpoint, from a marketing standpoint, from an advertising standpoint. Some recent numbers that have been bantied about is that there's generally a 20 to 30% consent rate on cookie banners. So if you move from a notice and opt-out regime to a notice and opt-in regime, you could see a 70% drop in data. And that may be, we may prefer consent from a legal perspective, but the digital teams, the marketing teams, the business teams may not like that. So that strategic consideration is a very important one to think through carefully. I think other pain points are when you're collecting email addresses or telephone numbers. Should you be obtaining consent? Should it be separate? Should it be a checkbox? Does it need to be a checkbox? How do your terms of use come into play when you need to leverage those terms in defending a litigation action with a class action waiver or arbitration? And the privacy policies, I think, increasingly are getting scrutinized by the regulators in a way that they weren't several years ago. And what I mean by that is the regulators are carefully looking at these generalized disclosures that most organizations make about how they use data or process or store data. And they're interrogating those disclosures, saying, would a reasonable consumer understand what you're talking about? Would they understand how the data is being used and shared, even at a categorical level? And I think that's the test for most organizations, is ask yourself, if this privacy policy and these disclosures were put in front of a jury or in front of a regulator, could you defend it and say this is explainable, this is easy to understand, which are regulatory requirements under the omnibus state privacy laws? So with that note, we're going to pause for a moment and provide you all with the second CLE code word. As was mentioned at the beginning of the webinar, we do need to take a brief moment to satisfy CLE requirements by delivering the following code word which is privacy. And this is required for all Kansas, New York, New Jersey, and Pennsylvania licensed attendees. You must type the code word privacy into the Q&A section of the screen. Make sure you hit the send button so that it registers. And in case you missed it, the code word is privacy. So we'll let folks get that typed in and give you a second. I think, Dalton, the pain point on the website side, especially around cookies and whether you're selling data and the use of third-party advertising technologies, sort of dovetails into this other compliance pain point that we see all the time, which is around contracting. Data processing addendums, DPAs, data privacy addendums, whatever you want to call it, these are riders to contracts that have some form of privacy disclosures and requirements. And DPAs are the bane of the existence of every legal and procurement department because they're not standardized, they're all written differently. Most people on this call probably have their own form that they like, and it's hard to ferret out what provisions are required by law, what provisions are negotiable, and what provisions are really unnecessary in a DPA. And organizations take a different approach to this. Some put in there both security and privacy requirements, some put in bare bones requirements. But I think an important takeaway for everyone is the omnibus comprehensive data privacy laws. So in California, it's the CCPA, and then you've got the other laundry list of states that Dalton was talking about earlier. They have express requirements in those laws for written contracts with service providers, which is the CCPA term, or processors under the non-California laws, as well as third parties to whom you are selling, sharing, or engaging in targeting advertising. And these requirements are very specific and oftentimes are missing from DPAs. This point came up in a recent enforcement action by the California Privacy Protection Agency when they were issuing a penalty against a company, because during the investigation, they said, well, it appears you have third parties who are a sale of data advertising partners, most likely online through these third-party tracking technologies. Please show us the contract you have with them that meet these requirements. And allegedly, the company couldn't provide those contracts, which was a violation of the CCPA. So bottom line here, I think, is to focus on whether or not you have either a written contract or a set of terms that you've agreed to with regard to every provider that would fit under these categories of service provider, processor, third party to whom there's a sale or sharing or targeted advertising, because you need to be able to produce those in a regulatory investigation. Now, there's pain points that come with these contracts, like every contract, definitional problems, reporting and auditing control issues, limitations of liability, restrictions of use of data, all of which are negotiable, but there are a core set of provisions that ultimately are not negotiable in the contracting space. But speaking of documentation, Dalton, I know another pain point that you've dealt with a lot is this requirement under the comprehensive laws to conduct data impact assessments and how those get doled out internally.
Yeah, to touch on the DPA question real quick before moving to the impact assessments. Another point of conflict, another pain point is cross-disciplinary communication between businesses, because a lot of times, I deal with third-party service providers who are contracting with an insurance institution almost every day, and the financial industry has specific requirements under laws like the New York Department of Financial Services Rule 500 that have additional limitations on secondary use of data, or that have tighter reporting requirements, or that have additional document retention requirements for service providers. And so, especially if you're dealing with a service provider that is not used to operating in a more heavily regulated area, communicating to them why some of these provisions are necessary can be almost half the battle to kind of prove up the fact that, no, actually, I know that you're not used to seeing these provisions, but they are necessary under our legal requirements and we can't negotiate them. especially for SaaS contracts where secondary use of data is almost a given. In more highly regulated areas, restricting that secondary use or really tightly defining the contours of what is acceptable can be a significant point of negotiation. Now, for data impact assessments, what we have seen in the past few years is that most of the comprehensive US data privacy laws require a version of this impact assessment. The triggers for that can vary by jurisdiction, and not only based on the text of the statute itself, because like we've referred to before, a lot of times you can line up the provisions of these statutes and they'll read almost identically right to left. You're just kind of transposing citations, but there are a couple differences, and those differences are harder to capture when you consider, like we've said before, the difference between the definition of what data is considered sensitive and what the definition of sale is in a particular jurisdiction. But those requirements were, you know, all things considered, not too terribly burdensome. You had to identify specific contexts in which the processing was happening in, which is good governance practice regardless. So like what the business use case is, what the characterizing the relationship between the consumer and the business, dictating what the benefits to the business were, what the benefits to the consumer was, what are the harms you expect, how can you mitigate those harms, and then kind of whatever the residual risk of harm was, if there was a risk acceptance decision, documenting what that acceptance decision was. Now, California's regulations, like they have so often done, are really changing that. So this past, just like last month or 2 months ago, the CPPA released their kind of final draft regulations on automated decision-making technologies, which included a risk assessment component. Well, I should say that they're updating the regulations. A component of that is these risk assessments, which cover using sensitive data and automated decision-making technologies and a couple other use cases. Adding on to that complexity, now there's AI regulations or AI legislation that's coming into effect, like under the Colorado AI Act, that require an additional kind of impact assessment. So if your organization has already invested or has policies and procedures in place for these impact assessments, if there's kind of the beginnings of a governance program, the pain point is how do we leverage our existing processes and kind of anticipate additional legislation, or if we're wanting to expand it into a new jurisdiction, there's legislation that exists there that we need to figure out how to work into our process. So how can we do that?
Yeah, I think that's a great point, Dalton. And I'm a big fan of not recreating the wheel. So if you do need to conduct these data impact assessments, regardless of the law that they're under, you should leverage existing assessments that you're doing from a cyber or from a privacy or from a digital perspective to understand what systems are collecting data, how they're using it, and where the impact may be. I think another pain point here is it's very difficult to carve out conducting an impact assessment for a particular use case, but not do it for another use case. And do you do it at a system level, an application level, a business process level? I'm of the mindset that most organizations are conducting these assessments at a process level at least once a year. They're analyzing how do we collect and use data on the website and having an impact assessment there. How are we collecting and using data in the HR function? How do we collect and use data over the telephone during customer inbound calls? So they have impact assessments per business function, which I think operationally is easier to navigate than to try to pick apart different processes and data points and try to conduct impact assessments at that granular level. Another area that we see, Dalton, that sort of issue of getting granular with the regulatory requirement and then operationalizing it is just around data retention. Data retention is a difficult task for most organizations. And the challenge that these privacy laws impose on the data retention landscape is most of the laws have a data minimization standard built into them. And they're not all the same standard. California is a lot more comprehensive. But at a baseline, what these rules say is that you should not be over retaining personal information beyond what is reasonably necessary, or to Dalton, to your point, for a secondary purpose that you've told people about and in most cases have obtained consent to use it for. So if you have a retention schedule, where does this rubber meet the road? Where does the challenge come in? I'll give you an example. Most retention schedules have data labeled as a record. So you have record categories. It's not specific to data. So you'll have HR records, personnel file, payroll files, etc. Now within payroll and within personnel, those files, those record types, you have multiple data points. So take the California Consumer Privacy Act. The CCPA says you're not supposed to over-retain personal information beyond what is reasonably necessary. For California, for a wage and hour dispute, the maximum statute of limitations is 4 years under the unfair competition law. Most data retention schedules have a retention period on payroll files as 6 or 7 years. And that's because other states have a 6 or 7 year tail on their statute of limitation. So the question is, if you are retaining a California resident's personnel or payroll file for 7 years post-termination, have you now just introduced a compliance problem under the CCPA and the data minimization rules? And that's where these rules can impact data retention schedules. So recommendation, key takeaway, carefully interrogate your retention schedule to make sure that you've got a justifiable legal reason for holding onto data for that period of time. And importantly, that you're notifying folks of that retention schedule and that intent in the various privacy notices that you may be distributing. So Dalton, I think with the time left here, I think we should just run through what we think are the operational best practices. So we've got the pain points, we've got the complicated landscape. Let's talk about operational best practices. And I will note for everyone, if you have specific questions that you want us to address, go ahead and populate them in the Q&A box and we'll pepper them in as we wrap up here. But Dalton, since I know you were talking about website, mobile app, notices, cookie banners, maybe you could kick us off with what we like to call digital health checks for organizations.
Right. So the most important thing is to understand what your website or your mobile app is doing at any given time. We will commonly see complaints where the plaintiff has inserted their analysis using tools like the developer tools in Google Chrome or the inspect function in Edge, and they're tracking the network activity on the website, and they're including that activity in the complaint. So we do the exact same thing. We have some additional tools that we can work with to do a digital health check, but understanding, all right, when the website loads, if I'm saying that our website's going to require consent prior to launching any kind of tracking technology, when I load the website, I can do an actual check to make sure that nothing fires until I hit the consent button. When I'm opting out of things, I can make sure that those cookies that there's a cookie drop that it will remember the fact that I want to opt out of those kinds of tracking technologies. I can validate whether or not a website is sending information related to a video that I'm watching. So testing all those components of the website, and especially from website to mobile app, there's been companies that I've worked with before where the privacy notice that is linked on the website is different than the one that's on the mobile app, or it's like an older version. And so making sure that the review processes for those are up to date and current, and that your development team knows that prior to pushing out any updates, we need to verify and validate that the consent functions are working. Consistently interrogating your privacy disclosures, particularly as enforcement surrounding clarity and ease of understanding continues to ramp up. And then the low-hanging plaintiff fruit that we've been kind of hitting over and over again regarding tracking technologies and collection and notice.
Yeah, I think important here is you need to review your website, all pages, all live domains, and your mobile app, and really walk through it like you're a plaintiff's lawyer or regulator at all points. Cookie banner, chatbot disclosures, collection of email, acceptance of terms, scripts that are running on the background. This is critically important because this is where there's a lot of monetary risk at play. I think another best practice, building off of the DPA nightmare that we're always dealing with, is develop your own DPA playbook, a checklist. We've done this for several clients. This is really helpful in walking through what provisions are required for our compliance requirements, what are negotiable, and why. Where does the statute come from? And training your contract and procurement teams. So this page just gives you a sample of one, but do you need to include this purpose limitation, and what are the statutory sources for that? That way, when the negotiation happens, you're not constantly needing to go back to your privacy counsel to say, do we need this? Do we not need this? I think this is a big sort of friction point in the sales and contracting process that can be cleaned up. Another area that we think is a best practice is building out your policy stack. So most of these state privacy laws that we've been talking about don't require that you have a written policy internally governing how you're going to handle data subject requests, how you're going to handle data minimization requirements, how you're going to handle the sale of data and opting out of the sale. But when there's a regulatory investigation or a lawsuit, oftentimes one of the first documents that's asked for are policy documents. I think another reason why building out a robust policy stack is important is in the M&A context. So we do a lot of work on both the buy and sell side, where we're doing privacy level diligence on either a target company or we are representing the target company. And I will say on the buy side, as a privacy lawyer, when we see a target company having a robust set of internal policies that are well crafted and specific to their compliance posture, it is a shortcut to thinking this company knows about data privacy compliance, takes it seriously, and has good practices. Now, it's always important to test, are they following those policies? But where there's a lack of policy, there can be a presumption either by the buying company, by a regulator, by a court, that you're not really following the law because you haven't focused on how the law impacts your operational needs. Finally, and Dalton, I know this one's near and dear to your heart, don't sleep on cybersecurity. Buried within a lot of these laws are requirements to maintain reasonable security with regard to personal data. And Dalton, I know you've got some thoughts here because we often deal with cybersecurity breaches, but these laws actually define personal data in a much broader way. So the cybersecurity requirements are actually more expansive.
Yes, that's true. So generally, breach notification laws, they are very restrictive in what they consider personally identifiable information or personal information. It's name in combination with another data element. Sometimes it can be something that you would think of as extremely sensitive, like a social security number or government ID. Sometimes it can be things that are linked to, identity theft, like your mother's maiden name or the password to a financial account. But these comprehensive consumer privacy laws, because the definition is so broad, your security obligations are just as broad. So if you have a data classification policy that has an associated security requirement document for different classifications of sensitivity of data, whether it's public, internal, confidential, sensitive, make sure that at the policy level, you're defining that all this personal information should be protected. Then the reasonableness standard is difficult because it changes from year to year. It is not static, particularly as in the past year, organizations underwent an extreme number of cybersecurity breaches, especially in the healthcare space. There are a number of prominent ransomware attacks and vulnerabilities that were exploited, and the drum that was being beat constantly from every regulator under the sun, whether it be a state or federal regulator, was follow a federal a federal framework like NIST or CSS or CIS or another appropriate framework. And in particular, we've had experience as cybersecurity attorneys doing control audits and policy review and making sure that programs are up to snuff under the power of privilege. And I think that's really important that you can leverage our expertise or the expertise of outside counsel to conduct a gap analysis prior to an audit or prior to a disclosure being made to a regulator to try and see where your weaknesses might be.
Yeah, and I think it's a great point to end on, which is call your lawyer, make sure your reviews of cybersecurity are privileged, and of course, ensure that your privacy review is comprehensive. With that, thank you very much for spending time with us and participating in today's CLE. In approximately 30 business days, you will receive an email with a link to your CLE certificate. Your webinar login details will be used to process those certificates, so no additional steps are required. And as a reminder, the code word requirement, it was only if you were seeking credit in Kansas, New York, New Jersey, or Pennsylvania. So on behalf of myself and Dalton and the rest of the Dalton's team, thank you very much for participating and have a great day.